like that until you get to 10 years. Is that
yes,
right?
Yes.
What he's seeking to do is to give the judge the discretion of giving you 1 year, 6 months. Can give you 2 months.
Yes.
Because that's what he's seeking to do.
Yes.
Basically.
Yes.
Because he looks at the offense and thinks that if you give somebody 5 years because then, for some reason he has made a mistake of disclosing information.
Then that is not how the proposal is supposed to be.
You should set the minimum.
Your minimum is, you are suggesting that the minimum should be 1 year. Then you said not
less than 1 year.
And then not more than, then you set the minimum and the maximum limit. But when you are coming to say not exceeding, so it means the judge will have a cause to say go home. Because you didn't tell the judge the minimum sentence. That is why, by practice, you give the minimum and the maximum, within which the judge must exercise the discretion based on the gravity of the offense. So for every offense, there must be a minimum and a maximum punishment.
You are representing, I think that we should look at it and see whether going to prison for 5 years for disclosing that information is a good thing or not. And I think that we should reduce it. It's excessive punishment. Seriously.
So, but in the first place, let's deal with the amendment in question, so that if there is any further amendments, it can be proposed.
So, can we still look at the period whilst we are discussing this? Can we now rather revert to maybe 1 to 10 years?
That is why I'm saying that.
Or 0 to 10 years.
Having regard to the proposed amendment on the floor.
Very well, Speaker.
Unless you want to abandon the amendment, so then do so
Speaker,
that we can deal with it.
That is abandoned, Speaker.
Very well. All members, the amendment is accordingly abandoned. Now, I'll put a question on entire clause 38 in the absence of any further amendment. If there is a further amendment, please let's do so before I put a question on entire clause 38.
Speaker, so I'm seeking to have a further amendment to say that it should rather read 0 to 10 years instead of 5 to 10 years. So less than or a minimum of 0 and not more than 10 years. Yeah, but 0 means that you can be cautioned and left.
Well, let's ask the drafter, is that what you intend to do? Sometimes punishment is supposed to be deterrent. Yes, Chairperson of the committee.
Mr. Speaker, just as a point of perhaps information, Act 1030, the same, it's under offenses for disclosure of information. This has actually been lifted from Act 1030, exactly as it is in the new bill.
I believe if you go further and we look at 525,
Speaker,
526, it may be the same provision.
That is the problem with the law. And that's the reason why this is the platform to correct it.
No, you see,
we can't say that because
if a provision has served us for all these years, you should have a very good reason from departing from it.
One of the reasons
I maintain from the beginning that the essence of the current amendment is just to do away with the enactment of the ministry and the functions of the minister. Yes.
Thank you, Mr. Speaker. Mr. Speaker, on this consideration, you've made this statement that we are not changing all the acts, we are just amending certain parts. We could have been done with that and then we wouldn't be here. But if we seek to change the law, Mr. Speaker, respectfully, let us go through some parts.
Maybe
that
you do not get the angle from which I am coming. I've even added that to change it, you must have a good reason.
526, 1030 has not served us well. And we are here to make changes. People have gone to prison because the judge's hands have been tied for something very little, for information that is trivial. But because the judge's hands have been tied by the law, they had no choice. So if we have an opportunity to make this amendment, the crime has been committed, let the judge decide whether it will be a caution to go home
So as
or 10 years.
a former minister, you
Yes.
would want to work with 0 sentence.
Depending on the gravity of the offense. Depending on the gravity of the offense. People have gone to prison
Yes,
for something that...
Honorable Minister.
Well, Mr. Speaker, my worry is former ministers in the security place saying this. Maybe because they are in opposition, they need information. But Mr. Speaker, they know the gravity. No, that was on the lighter side, obviously. Mr. Speaker, they know the gravity of some of the information that they've handled in the past and we are handling today. I mean, you carry so weighty information that sometimes you wish you can even discuss with your wife and you can't. Because you know the gravity of that information going out, how it can just destabilize. I mean, information from somebody from the intelligence can just destabilize the whole country. It can just create deaths. People can just lose their lives. So when you begin to say that, oh, this is minimum, this is, what are you going to use? Which scale are you going to measure which one is grievous and which one is not grievous? That is why it is severe for you to know that in the course of your work, you are not, the things that you get to see here, don't disclose them. If you fail to do, these are the consequences. So that people will be watchful. It's not a must that you must be in the security and intelligence agencies. You can have the right to resign. But Mr. Speaker, also remember, there is Whistleblowers Act that gives people also another route. But once you are working in this environment, you have chosen to be slave to information and zip your mouth. And you have an option to resign and go and become a parliamentarian where every day you can come to the chamber and talk the whole day. Like myself. But to say that we should make the sentencing minimum, Mr. Speaker, my only worry is that former ministers who have operated in this sphere and know the gravity of some of the information, even if you put gun on the former defense minister, I know information that he has, he would rather die than to say them because of what he knows the consequences of saying them will be. But somebody could be reckless and trade it off with peanuts. So that's why these sentences are there. And it's been there, Mr. Speaker, all these years as a guardrail. So please, let's keep the country safe. Because virtually you and I know, the only group that are left, that you and I can vote on, I mean, the former defense minister is there, and you've been in the intelligence place before, are intelligence and the defense guys. They are the only group left. If you want to open that lead too, you know the consequences. So please, let's leave it as it is. Thank you, Mr. Speaker.
Because I think it was during your tenure of office that they brought a regulation which says that if the intelligent officer is even going to marry, the kind of person that the intelligent officer must marry must be approved.
Thank you, Mr. Speaker. I take this as...
These are because of, these are some of the reasons.
Mr. Speaker, I take this as permission to speak. Mr. Speaker, the defense minister and myself, he was minister for 8 years, myself for 6 years. And we know what we are talking about. We are not talking about information that comes to us or some of our senior subordinates. This act also covers the gateman standing at national security. If you ask him, is the coordinator there, and he says that the coordinator, I've not seen him, or the coordinator has left, he's going to prison for 5 years because he's disclosed information. Mr. Speaker, that is what... So let the judge decide the gravity of the offense, whether the person gets 6 years. In this case, if you are saying minimum of 5, a maximum of 10, whether the person is getting 6 years, 7, 8, 9, or 10. Once that decision is to be made by a judge, all we are saying is that caution is also a form of punishment. Go and sin no more. A fine is a caution. So bring the minimum sentence to the barest minimum and leave the decision of the length of the sentence to the judge. That is all we're saying.
Honourable members, the proposed amendment, yes. I think we take the last comment and then we'll put a question.
Yeah, Mr. Speaker. Are we looking at clause 38(2)? 38(2). Clause 38. Yeah, 38(2). So you have to read one first. So I should read one to show that I understand. Okay. Subject to the Constitution and to Section 37, a person shall not disclose any information obtained by that person or to which that person had access in the performance of functions under this Act, or to which that person had access in the administration or enforcement of this Act, and from which there can be inferred. This is the operative word.
Yes.
This is the operative word. From which there can be inferred the identity of any other person who is or was a confidential source of information or assistance to agencies under this Act, or B, a person who is or was an employee engaged in covert operational activities of the security and intelligence agencies. Mr. Speaker, in some jurisdictions, you will be hanged. You will be hanged. 5 years, 5 years, 5 years, that's too generous.
Yes, it is not any ordinary information.
That is too generous. That
as in the case of
you are a member of the agency, you are involved in implementing the agency's mandate administratively, and you go and disclose the identity of an informant or the identity of an agent involved in covert operation, and you are talking about 5 years? Who even said 5 years? 5 years too generous, because that disclosure can lead to the person losing his life. You only need to read books about the Mossad and the operations and what usually will happen. Once you disclose the identity of the person, he will be killed. He will be killed. So why should you, a professional, disclose the identity and think that we should just, hand you a caution and then say you should go home? I mean, where have you ever heard that?
Yes.
But I can't understand that coming from a former minister for national security. Because you must do whatever it takes to protect your operatives. Your operatives must know that when they take the risk to engage in a covert operation, nothing will be done to compromise their identity. Nothing. Why? Somebody can take money and disclose the information and just go to prison for 5 years, come out and enjoy the booty. So I even think the 5 years is too generous. So I beg you, let's leave it. If we even raise the bar, let's not reduce it. Because in my view, actually the bar should be raised. Because I will not work for an intelligence agency if I know that if my identity is compromised, the person who compromises it is going to go to prison for only 5 years.
Oh, you are the last. You are the last one, because, Mr. Speaker, you see, majority leader may be passionate, but if you read it well, who is prohibited from the information being disclosed to? From what you have read. So if I go to them and disclose the information to the president, I'll go for 5 years. What's the meaning of no? So who determines that?
You see, Honorable Nitiwood, we came from 36, 37, before getting to 38, that is creating the offenses. So the previous provisions guides as to who and the circumstances that the information can be disclosed. And those circumstances are not being criminalized. But it is outside those circumstances. That's why they are providing for a punishment. And honourable members, let us not trivialize this. It's not just like a security at the gate stating that the minister is there. No. This is talking about the identity of a covered person. It's such a serious issue. So we should not trivialize it by saying that the punishment should be from 0. Oh no.
I think that I'm getting more aligned to the majority leader's submission. Say that I want to find out. Majority leader, since you made the submissions, I want to find out from you. Can the Minister of Foreign Affairs, Honorable Samuel Ablako-Kujato, who went to Chatham House to make some disclosures, can it be a part of the 5 years to 10 years? Does he find himself within the remit of 5 to 10 years?
Mr. Speaker, if you watch CNN and the international news outlets, yesterday, in Iran, I'm told that somebody was executed because they suspected him of disclosing information leading to the identity. Mr. Speaker.
Let us remember that we are at the consideration stage of a bill.
Yes. Mr. Speaker. Oh, but that question is not even a question. It's not even a question. The reason is that what information did the minister disclose? Yes, what information did he disclose? And how did that information disclose? How did that information disclose? Is that okay? Disclose the identity of anybody engaged in a covert operation.
Honorable members, I think we have come to a point that
the minister said,
Jerry Ahmed, you don't have the floor.
Is now Honorable a base for America to attack
Honorable Jerry
ISIS.
Ahmed, you don't have the floor. I think I would have to put a question on the issue so that we don't. Yes.
Mr. Speaker, Ghana became the base for America to launch operations because you passed an agreement. You approved it. Nitu, once was defense minister.
Honorable members,
he signed
let us not deviate
with the Americans, which
honorable members, let us not deviate from the bill. I intend not to open debate on this issue. I will therefore put a question on clause 38. As many as are in favor of clause 38 standing part of the bill say aye. Those against say no. The ayes have it. Clause 38 is ordered to stand part of the bill. Clause 39. Clause 39. Honorable Nitiwood, you don't have the floor.
But you mentioned my name.
Honorable Nitiwood, you don't have the floor. With all due respect. Clause 39.
Let me expunge it, Mr. Speaker.
Clause 39.
I have the right to respond. Otherwise, you expunge it. Because I never signed for a base in Ghana. Never have I. I have never signed for a military base in Ghana. If you have signed for a military base,
amendment, Honorable Nitiwood, with all due respect.
So let him withdraw.
You are a former senior. I give you that particular respect.
But Mr. Speaker,
so in a situation where you put on a microphone and begin to talk without giving the audience or catching the eyes of the speaker, is delving into a different realm altogether. I decided to truncate the argument because we are trying to deviate from the bill under consideration into other tangential matters. So, clause 39, chairperson of the committee, you have the floor. Clause 39. Chairperson of the committee, clause 39. Let him move the amendment. If you have an issue, we can deal with it. Yes, clause 39. The microphone is on.
Right Honourable Speaker, Amendment proposed for clause 39, delete. I so move.
The proposal is to delete clause 39, which is disclosure before Parliament. Any contrary view? Yes.
Mr. Speaker, I don't understand why the chair is proposing this, because if you look at the disclosure before Parliament and what it entails, I think that it's only fair that it's here. It's been there all these years. I don't know why we want to take it out. If the chair could give some explanation why we want this.
Well, Honorable Minister, we've progressed to establish a committee, and the members of the committee are being enjoined by our rules to take oath before they can sit at the committee to listen to the officers from the national security. So if by this act you are saying that an officer or employee of a security and intelligence agency under this act shall not be required to produce before Parliament a document or any other evidence when the Speaker certified that the document or any other evidence belong to a class of, yes, Minister, you are right. So why are you trying to delay this?
Right, Honorable Speaker, the committee, in consultation with 3 of our consultants, actually deliberated on this issue extensively. And the concern was that this specific provision would give a way out for decreased parliamentary oversight. And it was the opinion of the committee, not just of myself, Mr. Speaker, that this would be problematic in terms of parliamentary oversight and international best practice.
I beg to differ, because it is not every information that can be given to the committee. That is why there is a leeway here that if giving the information will be prejudicial to the security of the Republic, the Speaker will then order that the information should not be given. So I believe this is a very good buffer. Yes?
Mr. Speaker, there are some safeguards even under the 39(2), which gives the Speaker or the Council the right to refer such documents to the Supreme Court in accordance with Article 135. So with your kind permission, I'm sure everybody has the Constitution here, that the Supreme Court shall have exclusive jurisdiction to determine whether an official document shall not be produced in court because its production or disclosure of its contents will be prejudicial to the security of the state or will be injurious to the public interest. So it's very important we keep this provision, Mr. Speaker.
Yes, Honorable Majority Leader.
Well, if the Constitution confers on the Supreme Court the ultimate authority to determine whether information should be disclosed or not, is it within our purview to go and confer on the Speaker the authority to decide? Something that the Constitution says can only be decided by the Supreme Court. That's what the Constitution says, that if there is an issue about whether or not a document should be disclosed, that it has to go to the Supreme Court. What authority do we have to sit here and amend the Constitution and say, no, the Speaker can make such a determination? And it is only if we disagree with the position of the Speaker or the Council, then we go to the Supreme Court. Supreme Court is, the Constitution is clear that anytime there is a dispute, so if officers appear before a parliamentary committee and say, we cannot disclose this information, it's not for the Speaker to decide, no, you can disclose this information. It is only the Supreme Court. So I agree with the committee that that should be dropped, because we'll be interfering with the powers of the Supreme Court by conferring that authority on a Speaker of Parliament. I think the committee is right in this regard.
You see, the Speaker's certification is also constitutional. Let's look at 128, 121, 121, 2A. It reads, a public officer shall not be required to produce before Parliament a document where the Speaker certifies that the document belongs to a class of documents, the production of which is injurious to the public interest. So this particular provision is in tandem with Article 121A. So it doesn't derogate from the Constitution. Deleting it rather will contravene the provisions of the Constitution. So the law does not make it an exclusive preserve.
I think even 121 makes it easy for all of us. 121 consciously distinguishes between information injurious to the public interest and information of a national security character. You see, so we are dealing here with a legislation on national security. So we are dealing with a class of information that relates to national security. So even in 121, the class of information related to national security is not even within the purview of the Speaker. It is only information that is potentially injurious to the public interest. It can be information about anything. It can be a moral issue, it can be a health issue, it can be a sanitation, it can be any other matter. It may have nothing to do with disclosing information about the identity of agents, disclosing information about covert operations and etc. Even that, within the constitutional architecture of Article 121, is the preserve of National Security Council and not the Speaker. Where there is doubt as to the nature of a document, such as is referred to in Clause 2 of this article, the Speaker or the National Security Council, as the case may be, shall refer the matter to the Supreme Court. So again, two classes of information. Information injurious to the public interest, is that okay? And information injurious to national security. So what 3 does is to say that in these 2 instances, is that okay? If it is information injurious to national security, refer it to the Supreme Court. If it is information injurious to the public interest, is that okay? That one also refer it. So the 2 tracks are still maintained in 3. The 2 tracks are still maintained in 3. So my argument is that we are passing a legislation on national security, and not every matter injurious to the public, interest. So automatically, we are dealing with information under 1212B. 1212B. No. There's a matter injurious to the public interest. It may not be about intelligence operations or covert operations and intelligence-related matters. It can be any matter. It can be any matter. It can be matter about the identity of anything, a doctor, not a corporate, a covert operation. I'm saying that here, yes, it can be about the ownership of a Maybach, of a jet, or anything. It can be about the ownership of anything. But this bill is about covert operations, about intelligence officers, about their identities, and we are seeking to protect that. And we are saying that even before a committee, we cannot compel intelligence officers to provide the information. If we want to compel them to provide the information, we will have to go to the Supreme Court if they say that this is protected information. If we reduce it and say a speaker can give clearance, I mean, we will be downgrading an arrangement that the Constitution has put in place. That is my strong conviction.
Honorable Minority Leader, you see, Honorable Majority Leader, with all due respect, if you look at the provision, it says the Supreme Court, but it is the same Constitution, knowing very well that the Supreme Court may not have exclusive preserve in this matter, give room in 121 for Speaker to certify. So if the legislation is in all force with the 121, we can say that legislation should be deleted, such that any matter before the committee will not, the Speaker will not certify as indicated in the Constitution, but it must go before the Supreme Court. On this note, I beg to disagree with you that this particular provision staying in the bill will not offend the spirit and letter of the Constitution. Yes, Chairperson.
Right, Honorable Speaker. With regards to this specific provision, international best practice with regards to the governance of national security and intelligence agencies is exactly about why we are concerned with this provision. At the very least, we may make reference to Article 121 of the Constitution, because this specific provision is not Article 121. It has given a slightly different interpretation, which we are concerned will serve as a loophole. Prior to the establishment of the Security and Intelligence Committee, Mr. Speaker, I was a member of the Defense and Interior Committee, and I'm very much aware of the number of times we were not given access to very important information based on the fact that we were supposed to be a committee that did not have that level of clearance. So, Mr. Speaker, the concern with this provision is the fact that our ability to conduct our oversight role as Parliament might be impaired by the inclusion of this provision in the Act. Mr. Speaker, this was one of the provisions that was extensively discussed with the committee, with external consultants who are security sector governance experts.
So, Honorable Chairperson, if you delete it in this law, but the provision in the Constitution, which is the supreme law of the land, above and beyond which no further law exists, stays as it is, can the Speaker of Parliament certify that the document belongs to a class of documents, the production of which is injurious to the public interest, therefore it will not be disclosed before the committee, based on the provisions of the Constitution? So if the Speaker, based on the provisions of the Constitution, can do that, what difference does it make if same provision is in the law? Unless the Constitution is amended.
Mr. Speaker, in which case we have no problem with this being lifted out of the Constitution as it is, rather than in the form that it's presented.
Yes, so
in the
I will
bill.
direct the drafters to fine-tune this particular provision in line with Article 121 of the Constitution of the Republic of Ghana, instead of having it deleted. Therefore, I'll put a question subject to the direction to the drafters. All those in favor of Clause 39 standing part of the bill say aye. Aye. Those against say no. The ayes have it. Clause 39 is ordered to stand part of the bill. Clause 40.
Consequential amendments.
Clause 40.
Application of
Evidence Act 1975, NRCD 323.
Chairperson of the committee. Chairperson of the committee.
Right Honorable Speaker. 40, we have no proposed amendments.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 40? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 40 is ordered to stand part of the bill. Clause 41.
Protection of employees.
Chairperson of the committee.
No amendment proposed, Mr. Speaker.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 41, standing part of the bill, say aye. As many as are in favor of clause 41, standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 41 is ordered to stand part of the bill. Clause 42.
Regulations.
Chairperson of the committee, IX.
Right Honorable Speaker, Clause 42, amendment proposed. Subclause 2, delete and insert the following. 2, without limiting subsection 1, the regulations may provide
as advertised on the order paper.
Very well.
Page 20. Honourable members, it is for your consideration. Honourable Brian Champon, are you on your feet to speak on the amendment?
Yes, Mr. Speaker, we hurriedly went through 41, and I don't...
No, you have to move IX first.
We don't know.
Clause 42, IX, subclause 1, line 1. Delete may and insert shall. Please take the amendment IX before X. You have the floor.
Right Honorable Speaker, for clause 42, there is another amendment proposed, which is subclause 1, line 1, to delete may and insert shall. I so move.
Members, it is for the consideration of the House. Any proposed amendment? I'll put the question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment by the chairperson of the committee to clause 42 is ordered to stand part of the bill. Now, go and move X. Yes.
Thank you, Mr. Speaker. You are so very kind. Mr. Speaker, we hurriedly went through 41, which I'm not too sure if we all understood what we're talking about. Now, we are saying that every national security operative has the powers of a police officer. That is what 41 seeks to do. I'm not too sure if we read it properly. National security officers are national security officers. By saying today that national security officers now have the powers of police officers, 41, I'm not too sure if that is what we seek.
Honorable member, with all due respect, when we got to clause 41, I asked the chairperson of the committee whether there is an amendment. The chairperson said, there is no proposed amendment to clause 41. And I said it is for the consideration of the House. If you have a proposed amendment, all you need to do is to be on your feet and propose the amendment. So what then is your proposed amendment?
Thank you very much, Mr. Speaker. Mr. Speaker, 41 is conferring the same rights and powers conferred by law on police officers in the performance of their functions on national security operatives. So staff of the National Security Coordinator's Office now have the powers of police officers.
Yes.
Order. Staff of the National Security Coordinator's Office are not personnel or agents of a security and intelligence agency. we have we have defined security intelligence agencies, and that definition did not include the National Security Coordinator's office staff. So all those people that are engaged, that they are, personnel of National Security Coordinator's office, are not the categories of people that are being given the same status as police officers. We are talking about the professional officers in the recognized security and intelligence agencies. Properly so-called.
Yes, what is your amendment? Can we make progress?
Mr. Speaker.
With the explanation.
Yes, the definitions are nowhere to be found. The definitions are nowhere to be found. If we are talking about 41 is clear, subject to an officer or employee of the Security and Intelligence Agency. Exactly.
Well, and hold it. When we get to clause 43, interpretation, you can ask that we provide a definition for it, and that solves the problem. Yes.
Mr. Speaker, I see the attention that he's drawing, and he's right. The emphasis should be the intelligence agency, not security and intelligence. But when you say the intelligence agency, it's been defined as the internal and external, and restricts it to only this category. So an officer of the NIB can effect arrest and do all those things, but not the general security and intelligence. So what we simply may have to do is to delete the security and leave it as intelligent agencies, so that it may read, Mr. Speaker, the 42, that the council may, 41, subject to the Constitution, an officer or employee of an intelligence agency has, in the performance of functions under this Act, the same rights and powers conferred by law on a police officer in the performance of the function, and has the same protection, so that we restrict it to only the internal and external agencies. Thank you, Mr. Speaker.
The proposed amendment is for the consideration of the House. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 41 is ordered to stand part of the bill. Now I'll put a question on the entire clause 41. Again, as many as are in favor of clause 41 standing part of the bill as amended say aye. Those against say no. The ayes have it. The proposed amendment is carried. So, Chairperson, you may not move the amendment in X as advertised.
Right Honourable Speaker, amendment proposed for clause 42 as advertised. I so move.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. As many as are in favor of the proposed amendment by the chairperson of the committee at page 20, as advertised, say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 42. As many as are in favor of clause 42 as amended standing part of the bill, say aye. Those against say no. The ayes have it. Clause 42 as amended is ordered to stand part of the bill. Clause 43.
Interpretation.
Yes, Chairperson of the committee.
Right Honourable Speaker, this specific amendment proposed would be predicated on the decision of the House regarding whether or not there will be a Deputy National Security Coordinator maintained in the Act.
Well, by the law that we have passed, is there a position for Deputy National Coordinator?
No.
Yes, so this amendment becomes otious.
Very well. So I will abandon this amendment.
Very well. Then take XII.
'43. I think we'll have to abandon this proposal as well.
Also abandon?
Yes.
Then we go to XIII.
Amendment proposed definition of district chief executive. Delete and insert the following. District chief executive includes a metropolitan chief executive and a municipal chief executive.
All members, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment as in 43 XIII is ordered to stand part of the bill. Yes, 43 IV.
Amendment proposed, add the following new definition. District coordinating director includes a metropolitan coordinating director and a municipal coordinating director. I so move.
All members, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. XV.
Amendment proposed, definition of district security council. Insert the following. District security council includes a metropolitan security council and a municipal security council.
All members, any further amendments? I'll put a question. As many as are in favor of the proposed amendment say aye. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is carried. Honourable members, if you will not do the voting, at least remain silent and listen to the proceedings. Honourable Gumado, kindly take your seat. Kindly take your seat. 43 XVI. Chairperson of the committee.
Amendment proposed, definition for minister, line 1. After minister, delete responsible and insert assigned responsibility for. I so move.
All members, it is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. XVII 43. Yes, standing in the name of Osei-Mensah Alexander Afenyo-Markin. Honorable Jerry Ahmed, we have amendment as in XVII, standing in the name of the minority leader.
Speaker, I rise to take the amendment proposed by the minority leader, Alexander Afenyo-Markin. SVII. Speaker, I'm sorry, I think what I'm getting is different. Let me come back. Let me just capture it properly and come back.
In view of the fact that his amendment regarding the national security threat has not been carried, do we still provide definition for national security threat?
Speaker, I don't know if that has been captured as part of the definitions, but if not, then my advice is to abandon it.
Yes, so amendment is abandoned. We then move to proposed amendment XVIII. Chairperson of the committee.
Amendment proposed, add the following new definition. Security services mean the services connected with national security as determined by the council. I so move.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. As many as are in favor of the amendment proposed. Are you on your feet? Yes. As many as are in favor of the proposed amendment by the chairperson of the committee to clause 43, say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. I will then put a question on the entire clause 43 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 43 as variously amended is ordered to stand part of the bill. Clause 44.
Repeal and savings.
Chairperson of the committee.
Amendment proposed, subclause 2, line 6, after until, insert revoked.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. As many as are in favor of the proposed amendment to clause 44, say aye. Those against say no. The ayes have it. The proposed amendment by the chairperson of the committee to clause 44 is ordered to stand part of the bill. Now, the entire clause 44. As many as in favor say aye. Those against say no. The ayes have it. Clause 44 is ordered to stand part of the bill. Clause 45.
Consequential amendments.
Chairperson of the committee.
Amendment proposed, subclause 3, delete.
It is for the consideration of the House. Honourable members, I'll put a question. As many as are in favor of the deletion of clause 45, subclause 3, say aye. Those against say no. The ayes have it. The proposed amendment is carried. Now, a question on the entire clause 45. As many as are in favor say aye. Those against say no. The ayes have it. Clause 45 is ordered to stand part of the bill. Honourable members, the schedule. Yes, clause 46.
Transitional provisions.
Chairperson of the committee.
Committee has no advertised.
It is for the consideration of the House. Any proposed amendment to clause 46, a transitional provision? In the absence of any proposed amendment, I'll put a question. As many as are in favor of the transitional provision standing part of the bill, say aye. Those against say no. The ayes have it. Clause 46, the transitional provision is ordered to stand part of the bill. Now, the schedule.
Forms of oath.
Chairperson of the committee, any proposed amendment?
Yes, Right Honourable Speaker. For the schedule, amendment proposed, oath of secrecy on taking office, line 3.
Let me put a question on the oath of office first. I'll put a question on the oath of office. Those in favor say aye. Those against say no. Honourable members, the oath of office is ordered to stand part of the bill. Oath of allegiance. I'll put a question in the absence of any advertised amendment, so that when we come to the oath of secrecy, you can do your amendment. All those in favor say aye. Those against say no. The ayes have it. The oath of allegiance is ordered to stand part of the bill. Now, the oath of secrecy on leaving office. Chairperson of the committee.
Right Honourable Speaker, are you making reference to the oath of secrecy on leaving office?
Yes.
Or?
The schedule. That's where you have your amendment.
The amendment proposed is for taking office, not leaving office, Mr. Speaker.
Well, that is rather on the second. So let me put a question on the third and go back to the second. I'll put a question on oath of secrecy on leaving office. Those in favor say aye. Those against say no. The ayes have it. It is ordered to stand part of the
Amendment proposed, oath of secrecy on taking Oath of secrecy on taking office, line 3, delete and insert any. I so move.
It is for the consideration of the House. Honourable members, I'll put a question. As many as are in favour, yes?
Mr. Speaker, does it mean that you will have to be under this oath in perpetuity? Really? Really? Oath of secrecy on leaving office in perpetuity?
Yes.
But we have national security coordinators who have written books, Quantin and Co.
But they did not do a disclosure which will offend
writing a book.
The law.
All right, thank you.
As many as are in favor say aye. Those against say no. The ayes have it. The amendment is carried. We have to put a question on the entire schedule. Let's come to the long title. Yes, there are some outstanding clauses for the committee to work on. You have done it. If you have done it, let's go back and take it. Now, clause 14. Clause 14 was in the name of Honorable Kojo Nkrumah. Would a member move the amendment on his behalf? Fourteen has to do with the appointment under 195. He is of the view that it should be under Article 70 instead of 195. And I think by a debate of the House, we've come to a conclusion that doing it under Article 70 will give the National Security Coordinator an independent constitutional status like those there, which may in effect be a problematic because they are not creating the office as an independent constitutional body. That's why we have the ministerial responsibility.
I'll pray that a vote is taken so that at least that is captured.
Very well. Yes. I'm putting a vote on the amendment in clause 14 by Honorable Kojo Nkrumah. As many as are in favor say aye. Those against say no. The amendment is not carried. Now, clause 16. Clause 16, sub-clause 2, delete. The debate is to continue. Honourable members, the floor is now open. Honourable members, I think this was also clear. The essence of the deletion is that appointment under Article 195 is in twofold. Either the President will do it himself, and clause 2 of that article says the President can delegate. So, because of that, the committee does not deem it necessarily having it maintained here. Once the appointments are going to be under Article 195, the 1 and 2 shall apply. That's the essence for the deletion. members, I'll put a question on clause 16. As many as are in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 16 is ordered to be deleted. Clause 16, sub-clause 2 is ordered to be deleted. Now, clause 17. This amendment is in the name of Honorable Kojo Okon Nkrumah. It's been deferred. It's been moved and deferred. Now, debate is to continue. The floor is open for debate. Yes, Minister.
Mr. Speaker, sorry, at 16, you said you were deleting sub-clause 2.
Yes.
That's, with a greater respect, Mr. Speaker, the President may, in accordance with clause 2 of Article 195 of the Constitution, delegates the power of appointment under this section. That's why we are deleting.
Yes. And then clause 1 will read, the President shall, in accordance with Article 195 of the Constitution, appoint. And Article 195 is in 1 and 2. So once the President is appointing under the whole of Article 195, he can delegate under 195 too.
Sorry, Mr. Speaker. Then I come to the 17. I know which my colleague, Honorable Kojo Okon is here. Mr. Speaker, the reason why what he's doing may be problematic for us. For example, if you look at the external agencies, he's going to elaborate virtually all the details that they do. It is a huge exposure as compared to we putting them together and saying that this is done, and in that way find a way of neatly not really overexposing our external intelligence gentlemen and ladies. Because, for example, to say that if you look at his proposed amendment, and in particular F, conduct due diligence on foreign entities and high-profile personalities, including ambassadors designate or high commissioners designate, and profile persons of interest. I mean, which country will allow your external agency into any meeting? It is not said, but we know all around the world that these are things that are done. So, Mr. Speaker, I will be happy if we draw this amendment and allow it to stand as in the bill, because it carries, what you look at in the bill, we have in the bill, carries the sense of what we really want them to do without necessarily exposing the fine details of which activities that they are carrying. So I'll be grateful that we'll put the question on this and then be able to put it to rest. Thank you, Mr. Speaker.
Mr. Speaker, I agree with the Minister for Interior, because there is nowhere in the world that you legislate and expose people who gather intelligence for you. It's for good reason that officers at the research department are placed under the Ministry of Foreign Affairs, even though they don't report directly to the Foreign Minister. They report to the National Security Coordinator or the National Security Council. Nobody does that. And that is why there are certain things we cannot even say on the floor as to what they do and where they are placed even at our missions. Because if their cover is blown, they cannot even be allowed to enter certain places, because you need passes to enter certain places. Why will America allow you to enter the White House if you are designated as an external intelligence officer? Your cover is blown. Yes, your cover is blown. So nowhere, no civilized jurisdiction legislates and elaborate on this, and I think it has to be struck out. Thank you.
Well, honourable members, if it is not withdrawn, I'll be compelled to put a question. Honourable members, I'll put a question on the proposed amendment by